Counsel, the U.S. Supreme Court recently granted cert in the Elonis case, where it's quite possible that they may refine or elaborate a bit on the test for true threats. It is conceivable that given this court's constitutional obligation to decide cases within 2 terms of court, that we'll have to decide this case before we hear from the High Court on Elonis. Do you have any thoughts about how this court might be able to work around that uncertainty as to how the Elonis case may come out?
Yes, Your Honor. The issue in the Elonis case is whether to be a punishable true threat, it's enough that speech be reasonably perceived as threatening, or there also has to be intended to be threatening. Under the statute at issue in this case, though, there already has to be a showing that the speech was intended to be perceived as threatening. So regardless of which way the Elonis case comes out, the statute would only apply to speech that is intended to be threatening and reasonably perceived as threatening. Now, under the Bose Corporation versus Consumers Union case, in First Amendment cases, appellate courts ought to exercise independent appellate review, at least as to judgments of application of law to fact, such as whether the statements are reasonably perceived as threatening. We think in this case, this independent appellate review would yield the result that these statements are not reasonably perceived as threatening. But again, even if you disagree and conclude that some of the statements could be reasonably perceived as threatening, regardless of how Elonis comes out, all the other statements, the many hundreds, I believe even a couple of thousand statements that were not cited as potentially threatening, would be constitutionally protected.